right, so before we go on the record, I will give both parties a chance to address final issues, and then I'll make my ruling.
Oh, I don't have anything more to say on that.
All right, well, we'll see if maybe the state has something else they want to say with regards to it. So the court is calling 2025 CR 003338. State versus Carlos Vasquez Saldana. Can I have parties announce?
Megan Galloway for the state.
Roberto Vargas for the defendant, ready to proceed, Your Honor.
And are you Carlos Vasquez Saldana? You need to respond yes or no.
Yes.
All right. And we have an interpreter here. If you could raise your right hand for me. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
My name is Catalina Delgado, spelled Delgado, license number 2222.
All right. So we were here for a bench trial and there was a motion to suppress presented during the bench trial as well. So the court recalls the evidence as follows. The defendant was pulled over for an expired registration. And after he was pulled over for an expired registration, he was asked to step out of the vehicle. He was placed in handcuffs. And once he was placed in handcuffs, then there was a question of his consenting to search. So the officer asked to search and he gave consent when he was in handcuffs. Is that correct?
No, Your Honor, it's a language barrier, so they call the second officer.
No, I mean, I know that's in between where they call another officer to come out to interpret, but my memory is that you have the expired registration, then he's placed into handcuffs, and then he's asked to give consent to search.
That's correct.
Well, I just want to be more specific on the record, Your
Okay,
Honor.
go for it.
The arresting officer realized he didn't speak Spanish, so he called the second officer. At which time they waited for the second officer to show up, and the second officer showed up. That's when he started to interview the guy. And he asked him if he can search the vehicle in Spanish.
All right, so my understanding is from reviewing the video and listening to the testimony, it wasn't as though that there was an hour time elapsed between the officer requesting someone who spoke Spanish or an officer who spoke Spanish to come on the scene. My understanding is there wasn't a unreasonable amount of time between the English speaking officer and the Spanish speaking officer arriving. Is that correct?
I don't know how much time went by.
It was the amount of time that elapsed between when the first officer pulled the defendant out of the vehicle to when the second Spanish speaking officer arrived was less than 5 minutes. And I think that would be supported by the evidence that was admitted in the trial.
All right, so what the court can say in reviewing the video, the consent to, the arrival of the Spanish speaking officer, the court is going to find that there wasn't an unreasonable amount of time that the Spanish speaking officer arrived after police had first contact with your client. So does anyone want to again address the issue of his giving consent to search while he was in handcuffs? Because I believe that's the crux of your argument, that the consent to search wasn't voluntary.
Yes, Your Honor. Just when the second officer showed up, my client was already in handcuffs in the back of in front of the police car. At this time, he's in handcuffs and no one has told him what he's being charged with or why he's being detained. When the second officer showed up, he speaks Spanish. He should initially told him what he was charged with before he started the conversation. He should have also read him his rights in Spanish. The second officer speaks Spanish. There's no reason why they needed to call the third officer so he can read him his rights in Spanish. But that's the heart of my argument is that the second officer speaks Spanish. He just asked him questions, didn't tell the guy what he was being charged with. He just started asking him questions. And my client was nervous. It's reasonable for a person late at night being taken out of your vehicle in handcuffs and no one's telling you what you're being charged of, and they're bringing a second officer who speaks Spanish. He could at least have the courtesy to tell him, hey, you're being charged of this, and then ask him questions, or you're being charged of this. I'm gonna read you your rights, and then I'm gonna ask you questions. After I read you your Miranda rights, do you consent to a search?
But
The
do
guy's
you
nervous.
need to give someone their Miranda rights in order to obtain a consent to search?
Well, in this case, you would, because the guy's in handcuffs. I mean, the guy's just standing out there like anybody. You don't need to read him his rights, but this guy was under the impression that he's under arrest because he's handcuffed and no one tells him what he's charged with. So if you're under the impression you're under arrest because you're in handcuffs, I think you should read him his rights before you start speaking to the person.
But didn't they say that, or the video shows that he's being detained and the officer testified that he's being detained? And the reason why he has him in handcuffs, the officer testified that when he pulled him over, that he appeared to be making furtive movements in the vehicle.
He said he saw my client, see my client's as tall as me, while driving, reaching into the glove compartment and playing with it, with tinted windows. I'm as tall as this guy, and I tried to check my glove department the other day. It's impossible without weaving. The windows were tinted, so it's a question of credibility of the officer. But either way, no one told him why he was in handcuffs. Officer told us in English why he did it, but he never told my client why he put him in handcuffs. And that's the most important thing. If you're gonna put someone in handcuffs, you know, you tell them why you're doing it.
All right. And then my understanding from the testimony reviewing the video, he was only asked one time whether or not he would consent to the search of the vehicle.
Yes.
Okay. All right, State.
Judge, my response is just that at the time that the defendant was placed in handcuffs by Officer Johnston, it was a legal detention. At that point, the defendant had failed to identify himself, and so that, in addition to the furtive movements that were observed and testified to by the officer, gave him the ability to place the defendant in handcuffs for officer safety, which was also testified to. At the time that the second officer, Officer Garza, was communicating with the defendant, although he was in handcuffs, no arrestable offense had occurred at that time. And I think that's important in the court's consideration of whether a custodial interrogation was taking place. In the case that I submitted to the court the last time that we were here, it states that no Miranda is required to obtain consent to search. And regarding the handcuffs or being in custody, that's just one factor for the court to consider, in addition to the other factors in the cases that I provided, such as the law enforcement presence, the place of the stop, and all the other factors that that are obtained in the case law. And so we would ask you to deny their motion.
All right, defense, I'll give you final argument if you have any more information to add.
Other than the fact that, Your Honor, he was put in cuffs because the officer believed he was in danger because he allegedly thought he saw my client reach into the glove department. Based on his experience of less than 2 years, there was no traffic violations. My client wasn't under the influence of drugs or alcohol. Right off the bat, there was a communication problem. And it's not, they wasn't trying to deny his ID. They just, he didn't understand what my client was saying. But the simple fact is, if you put someone in handcuffs, in my case law, what a reasonable man would think, you got me under handcuffs if you're hanging in front of your police car and you yet to tell me anything and you wait for another officer, I'm going to assume that I'm under arrest. And at that point, his Miranda rights should be kicked in so he can decide if he's going to answer questions or not. At least he knows his legal rights. As far as him only being asked once, well, you don't have to be asked twice. If you're scared, you'll answer right off the bat. But under the reasonable person point, if I was in handcuffs in the back, I'm thinking I'm going to get arrested. So at that point, second officer shows up, got rookie officer should have went and told the guy, hey, this is what he's being stopped for, let him know. Read him at Miranda rights. Instead, he just went straight, he started having a conversation like they're friends. Like, you're not my friend if you have me in handcuffs.
Mhm. But doesn't the conversation, as you said, as though they're friends, doesn't that speak to voluntariness, that it wasn't a,
No,
a, that it wasn't an intense situation, at least from the officer's standpoint, and from your client's standpoint, it wasn't a contentious interaction.
I mean, from the officer standpoint, he's talking to you as a friend, but as far as the one in handcuffs, hey, you're afraid, you're going to, for all you know, you're being arrested. You don't know what you're being arrested for because no one has told you up to this point.
So are you saying that if there were no handcuffs on him and he consented to a search of the vehicle, then it would be legal?
Absolutely, Anna, because you feel more comfortable if you're in handcuffs. But you're handcuffed with your hands behind your back with the lights on and the second officer shows up. I mean, any reasonable person would think he's gonna get arrested.
But with it, and let's talk a little bit about the language barrier. So the officer who communicated to him about the consent to search, that officer was a Spanish-speaking officer, and that officer spoke to him in Spanish?
Yes, Your Honor.
And that officer explained to him the consent to search form in Spanish?
No. He just
Right, what do you
asked-
mean, no?
He just asked him, can we search your car? And he said, yes.
All right, so he understood that it was a consent to search form and he agreed to the search in Spanish.
He didn't sign no consent. It was all verbal, Spanish translation. But like I said, if you're under arrest, you don't know your rights, you're nervous, you're handcuffed, you're gonna cooperate with the officer under duress.
All right. This is what the court is going to decide. The court, based upon the evidence that was presented to the court, and the court has considered arguments of both sides, the court is going to deny the motion to suppress. Now, with regards to the evidence that was presented, counsel, you want to make closing arguments?
Just let me get my
Yes.
points. Whenever you're ready, Your Honor.
Yes, I'm ready.
Your Honor, the issue before the court at this point has the state proving the case beyond a reasonable doubt. I submit they have not.
Oh, if you'll slow down a little bit, because she's translating it then.
Regarding to the facts of the case, the officer saw my car traveling in a high crime area late at night. No, did not witness any traffic violation, just ran the plates and found that there was a expired sticker, so he initiated the stop. As the officer followed my client, he states he saw my client reaching into the glove department. The officer states that my client passed up several parking areas, public parking areas, well, they where he could have parked. But instead he pulled over on the side of the street. But at no time did he try to evade. He was driving slow enough for the officer to keep pace with him. Now, when the officer stated that he saw my client reaching into the glove department while he was driving, like back windows were tinted, and it was his opinion that the light on his car showed shadows where he was extending into his glove department. But the video speaks for itself, John. When you look at the video, you can't see any shadows, people extending back and forth.
Mhm.
As a result of that, he believed he was in danger based on his less than 2 years experience as an officer, and approached the driver's side of my client and pulled him out and handcuffed him. But as you watch the video up to that point, my client had his hands on the wheels and was cooperative with the person. You know, there was a language barrier. as a result of the language, as a result that he saw him reach into the alleged blood department, he pulled my client out, put him in handcuffs, took him to the front of his police car. And at which time he radioed for a second officer who spoke Spanish to come and help him. And the second officer arrived, no time did him or my client, and no time did this officer or the other officer tell him why he was being stopped and what he was being charged with. The officer just started to ask him questions. At this point, he asked my client if he, because during that conversation, my client told him that it wasn't his car, it was his boss's car, that he was borrowing it. When asked to search the vehicle, my client consented. This is still prior to any Miranda rights. During the search, the officer searched the front, the middle console, and underneath some stuff he saw some paraphernalia involving to use to smoke. And based on his experience, he thought it was a drug paraphernalia. So based on that, he continued the search. He searched the front seat, he searched the glove compartment, he searched the back seat. Nothing until we reached up top where the glasses are and he found some stuff. If it's testimony, we have this testimony to be truthful. We hold it officer's testimony to be truthful, then the only movement that he saw my client do during the drive was reach for the glove department, never did he reach for where the glasses should be. Well, all officers told him that he was stated that he didn't, I think he was not under influence of any drugs or alcohol at the time. And the second officer spoke Spanish, which time when they found the drugs, should have read him his rights. Instead, they called in the third officer to read him his rights. Most people that borrow someone's car, they don't do an inventory check of the vehicle before they drive it, so they don't know what's in the car. Unfortunately, things like this happen. Based on the circumstances, Your Honor, I mean, if he's borrowing this car and the officer's only testimony and saw him reaching the glove department and never looked up there, and then my client would have had drugs, we would probably told him he had drugs because he told him he can search the car. He was being honest with the guy. He wasn't aware of these drugs. Based on the circumstances, perhaps it can be my client's drugs, but that's not good enough to find him guilty. You know? He can suspect it is my client's drugs because he is the only one in the car, but that's not good enough to find him guilty. You know? My client is possibly guilty of possession of drugs, but that's not good enough to find him guilty. Your Honor. My client is probably guilty of possession of drugs, Your Honor, but that's still not good enough to find him guilty, Your Honor. My client is likely guilty of possession of drugs, Your Honor. That still doesn't reach the burden that the state has to prove that he's guilty. My client is highly likely guilty of possession of drugs, Your Honor. That still doesn't meet the standard for the state to meet to find my client guilty. And based on the testimony of the officers that we heard, Your Honor, the state has failed to prove guilt beyond a reasonable doubt, and that's that you find Carlos not guilty.
All right, state.
Your Honor, we have proved the elements of the indictment beyond a reasonable doubt. Beginning with the honor about January 2nd of 2025, Officer Johnston did testify that he was on patrol in a uniform in a marked patrol vehicle on that date when he observed the motor vehicle that the defendant Carlos Vasquez Saldana was operating on a public roadway. Officer Johnston testified that he did run the license plate belonging to the vehicle and the registration came back as expired. And that is the reason for the traffic stop that he initiated. When he initiates his red and blue overhead lights, I think it is of significance that the defendant did not immediately pull over. And the state's exhibit, you can see that the defendant passes up two well-lit areas that were parking lots that he could have pulled into. And while it does not rise to the level of another offense, I think that lends to the officer's credibility of the furtive movements that he observed the defendant making during that time, and also to a consciousness of guilt. Now moving on, when Officer Johnston does initiate contact with the defendant, he does observe him in the driver's seat. There's nobody else in the vehicle. It did come out during testimony that the registered owner is not the defendant. However, he was in exclusive possession of the vehicle. I think that important facts that link the defendant to the car is you see in the state's exhibit that he's wearing a red hoodie that has a construction company. When the officer does search his person, he finds nails in the pocket. There's multiple tools in the car, linking the defendant to the car. Officer Garza does make the scene, and he is the second officer on scene. He's a Spanish-speaking officer that obtains the verbal consent to search. At that time, Officer Johnston goes to the car. He finds a pipe that is consistent with smoking narcotics. At that point, he takes it over, shows Officer Garza, and then he goes back and continues to search the car. When he's searching the car, the methamphetamine does fall down from the sunglasses case that is seized, sent off to the lab. And the forensic scientist did testify that it was 0.253 grams of methamphetamine. Now regarding the affirmative link, or what affirmatively links the possession of the narcotics of the methamphetamine to the defendant, is that broken piece of the pipe that Officer Garza testified that he seized from the defendant's pocket. And so that goes to the intentionally and knowing of the indictment. And so we have proved this case beyond a reasonable doubt, and we ask that you find the defendant guilty.
All right. The court will find the defendant guilty. If you could pull a trial court certification of defendant's rights to appeal, please. And then we'll move into sentencing.
Okay.
All right, the court having found the defendant guilty, state, what are you requesting for punishment?
Judge, the defendant does not have any criminal history or any prior felony convictions. And so I think under 42A.551, he is mandatory community supervision. So we're just asking for 2 years probated for 2 years.
We're asking for 1 year probation, Your Honor.
The minimum is 2. So-
We're in agreement there.
All right, sure. So the court will sentence you to 2 years in the state jail facility, suspended and then probated for 2 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors, bill visits 1 time per month for 3 months, a TAP evaluation in custody, follow recommendations. And your client is not a citizen, correct?
Oh, yeah.
And there's to be no illegal re-entry into the United States. Probation, is there anything else? All right, Mr. Saldana, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes,
All right. And counsel, were you ever able to explain this document to your client in in Spanish?
Yes, I used a translator, so there's no mistake, Your Honor.
Great, thank you. All right, you do have a limited right to appeal. Well, not a limited right to appeal. You have a right to appeal because this was a bench trial. And also you have a right to appeal the court's rulings, any of the court's rulings. Do you understand?
yes,
All right, because this is a conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
okay.
All right, good luck to you. Thank you.
May I get excused, sir?
Yes.
Thank you.
Thank you. Yes.
Thank you. Delgado.
Thank you.
Thank you, Your Honor.
I'll probably do a court appointed attorney.
Well, no, here's the thing. You have to be interviewed to see if you qualify. You just can't say,
I like to be interviewed.
all right, Ms. Ferguson, if you can see if he can be interviewed for an attorney. All right. All right, who's here on Amanda Hernandez?
First, Gerard.
And then after Amanda Hernandez, it'll be Leroy Beal.
Where you go?
No, I don't have that. Everyone, if I have not called your case, it's because I don't have your file. All right, the court is calling 2025 CR 0000174 and 2025 CR 007073. State versus Amanda Hernandez. Can I have parties announced?
Rick Pena for the state of Texas.
John Young for the defense.
And are you Ms.
Amanda.
Hernandez?
Your Honor, it's an oddity in the system, but I have two Amanda Hernandez's right now, so I would ask that she be identified as Amanda Marie Hernandez.
You are Amanda Marie Hernandez?
Yes.
Counsel, in each of the cause numbers, did you receive all of the discovery and did you review it with your client?
Yes, Your Honor.
In each cause number, the court will find that the state is in compliance with discovery. In each cause number, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it?
Yes.
Counsel, I'm sorry, Ms. Hernandez, in each cause number, did you review the documents entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
And counsel, do you waive the reading of the indictments?
I do, Your Honor.
State, are you proceeding on the indictment as presented in each cause number?
For both cases, yes, Your Honor.
Ms. Hernandez, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
In the cause number ending in 7-4, you're charged with fraudulent use or possession of identifying information less than 5 items. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
In the cause number ending in 7-3, you're charged with injury to a child or elderly or disabled person, bodily injury. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
I did.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
I did.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call and the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cases? Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes,
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she is and was.
Mr. Hernandez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. In each cause number, did you review the plea bargaining agreement with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, the causes are to run concurrently. The state is taking in consideration 2024 CR 011068. In the cause number ending in 73, there's a affirmative finding of family violence. There's to be no contact with the complainant or the complainant's address. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as a primary custodial parent?
Yes.
And in the cause number ending in 7-4, yes,
I believe with the 7-3 case, there was a fine as well.
a $1,500 fine.
And I'm going to
That the
be
court is
asking
gonna
the court to
probate.
probate that, Your
Yeah, I
Honor.
will probate that.
Thank you.
All right, and then the cause number ending in 7-4. There is to be restitution to Audrey Bash, Roberto Alfaro, Arturo Olivares, and that's to be determined. Did you understand that to be the plea in each of the cause numbers?
Yes.
Defense is at the plea.
Yes, it is, Your Honor. I have also told my client that if there is any objection to the amount that probation determines as restitution, that I will ask for a hearing on restitution with the court.
All right, state is at the plea.
That is the plea, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes. ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
There have not, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 6 years. There'll be 100 hours of community service restitution, no contact with the complainants, anger management, TAP evaluation, follow all recommendations in MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then in cause number 2025 CR 000174, how do you plea?
No contest.
And in cause number 2025 CR 007073, how do you plea?
No contest.
State any evidence.
As to both cases, Your Honor, state offers into evidence exhibit 1 with all attachments.
No objection, Your Honor.
All right, and state, have you spoken with the complainants?
We have, she's here, and at the conclusion, she'd like to give a victim impact statement.
All right, state, you may be excused.
Thank you, Your Honor.
Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand that by entering this plea, again, you're giving up your right to jury trial, a right to remain silent, and the right to cross-examine witnesses?
Yes.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and will review the same.
Yes.
Members, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I know that she, even though I am retained, that she does not have any money or in her own name. I was hired by a gentleman that is a friend of hers. I know that he intends to abide by this. I've explained to her that the court normally will review a request for early termination if she completes everything she does, has indicated to me she intends to try to do that.
All right. Do you have any children?
Yes.
What are their ages?
They're a year older than 18.
All right. What are their ages?
25, 19, 18. Yeah, I don't even know. 23.
You don't know?
I don't.
All right.
He wasn't in my life.
All right. When's the last time you were employed?
Prior to coming into jail, so, about 4 months ago.
Doing what?
Care.
And who were you caring for?
My best friend and 2 neighbors of his.
All right. Who is Oscar Lara III to you?
Oscar Lara.
The person you were in the vehicle with when all of these cards were found?
In the vehicle, I was by myself.
Yeah. According to the stipulations, it says officer observed a male and female enter the Lincoln, and that's the Lincoln vehicle. Yeah.
Oh, that's Paul.
No, there's a Oscar Lara III. That's a different person. And you also have Paul Vasquez Jr.
Yes, Paul Vasquez is the one that was in the driver,
All right, so who is he to you?
uh, person I hung around with.
And who is Oscar Lar the third to you?
That I don't know. I don't know that person.
And who is Roberto Alfaro to you?
My ex. Okay,
All right, when's the last time you used any type of drugs?
about 7 months ago,
And what do you use normally?
heroin.
Okay,
I've been on Suboxone that's how I got off of it prior to coming over here.
all right, I understand when people say they're off of drugs and then they get on another drug, so they
Yeah,
want to
no,
use the
okay, that-
drugs.
But I had stopped, but yeah, I know.
I mean, it's still a drug,
I
right?
understand.
Do you have any violent history?
No,
All right, this is what the court is going to do. In cause number 2025 CR 0000174. The court is finding there's sufficient evidence to find you guilty. The court will defer finding of guilt. The court will sentence you to 5 years deferred adjudication. This will run concurrent with 2025 CR 00773. Take into consideration 2024 CR 0111068. There's to be restitution to Audrey, Audrey Bash, BASH, Roberto Alfaro, Arturo Olivares. Regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days of release, no employment as a home healthcare provider or with minors, no residing with minors or the elderly. Field visits 1 time per month until further notice. There's to be a referral to felony drug court and Esperanza Court in custody. And there is to be 150 hours of community service restitution and 60 sober support meetings in 60 days. Probation, is there anything else? Is there anything else you need from the court with regards to that case?
no,
And cause number 2025 CR 00773. The court will sentence you to a $1,500 fine. That will be probated. This will run concurrent with 2025 CR 0000174. Take in consideration 2024 CR 0111068. There's an affirmative finding of family violence. There's to be no contact with Myrna Espinoza Portillo or Yukon Boulevard. 100 hours of community service restitution, anger management, proof of employment within 45 days, no employment as a home healthcare provider or with minors, no residing with minors or the elderly, field visits 1 time per month until further notice, a referral to felony drug court and Esperanza Court. That's to be done in custody. And in each cause number, there's to be a TAP evaluation in custody, follow recommendations. And there's to be 60 sober support meetings in 60 days. Probation, is there anything else? Is there anything else you need from the court in regards to that case? And each of the
This cause number.
the term on this cause number is 6 years.
Your Honor, can I ask you to reconsider the referrals to both Esperanza and drug court in custody? I know that my client, part of her reason for entering these plea bargains was in order to get out of jail.
No, you need help, you have a drug or alcohol problem. And your drug or alcohol problem is what brought you here today. You understand?
Yes.
All right, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes,
Because these are plea bargain agreements, because I followed your plea bargain agreements, and because you waived your right to appeal, you do not have the court's permission to appeal. And cause number 2025 CR 007073, because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
yes.
All right, we can go off the record. In this court, communication is key. If there is an issue, you need to let your probation officer know about it. If you feel as though they're not addressing it, you can always come back to the court. Do you understand? All right, so here's the other thing. You're not allowed to be a home healthcare provider. You're not allowed to take care of the elderly. You're not allowed to take care of minors. If you do any of those things, it's going to be a violation of your probation and a motion to revoke is going to be filed. You also are not allowed to live or reside in any household where there are minors. Do you understand? And where there are elderly persons. You understand?
Yes.
All right, good luck to you.
Your Honor,
Yes.
the definition of elderly is sometimes a little fuzzy. My interpretation of that is it's a person over 65 years of age.
All right, so
When
let
they
me
cannot take care of
clarify. How old are you?
I'm 45.
You're 45. You cannot, Vashan, for her, 45 is 10 years older than whatever she is. So you're not allowed to live with anyone who is 55 or older. You understand?
Okay.
All right, thank you. Who's here on Amanda Hernandez? Amanda Marie Hernandez. Oh. Oh, okay, thank you. Clinton Dixon.
He went outside.
All right, just have a seat. Roman Flores. Who's here on Roman Flores? Okay, thank you. Gilbert Salinas.
Yes, Your Honor. May I approach?
All right, where's the client?
Peace.
Come forward.
Oh, good.
All right, let me see. All right, so Mr. Salinas, today is your plea deadline date. So are you requesting a jury trial?
No, Your Honor. What I'm requesting is a 2-week, no more than 3-week reset for the plea deadline because we're trying to get with the apartment complex to find restitution amounts, if any, so they can properly evaluate the offer that the DA has made.
All right, Norma. Recall this for the week of July 7th. There will be no further extensions.
I understand, Judge, and I greatly appreciate that.
All right. All right, July 8th. And you'll need to be here in person.
Yes, Judge.
All right, once you sign the reset form, you excuse.
Thank you.
Thank you.
Yeah, no, you want, take care of that first. So take care of it first. and then- That's your fault.
Judge, may I approach?
Just give me a moment. I have to put this in the system.
I wasn't going to.
Um, Clinton Dixon. Hi.
Judge, I apologize for not being here when you called me. I had to go get a tape measure.
Oh,
He's gonna need you close.
oh, most definitely. So you all are going to trial?
Not yet, Judge. You asked me to come back in today,
You're
but
gonna get that information, but this is going to be trial?
I'm hoping not, but
Okay.
I've got to get Dr. Murphy's from court first. I talked to her this morning. The package that she needed from Mr. Dixon is en route to her.
Okay,
So she's thinking 3 weeks.
all right.
Now, if she's got to do an in-person visit with him, it'll be longer. But if she does it by Zoom, it'll be 3 weeks.
All right, so. All right, the week of July 14th, that's the final date I'm giving you all.
Your Honor, if you'll give me just a moment.
Sure.
Uh, Judge, I'm out of state from the 11th to the 20th with the court.
I can bring you back the 7th or the 8th
Of
of
August,
July.
of July. I don't know if that's going to be enough time for her to do
When are you gonna be back?
the 20th of July. It's a Sunday, I think.
All right, Norma, set this for the 21st.
You're most kind, Your Honor. Thank you, sir.
Sure. There'll be no further extensions of the plea deadline date.
Thank you, Your Honor.
Is there anything else?
No, Judge, I think that will cover it. And if I get any indication from Dr. Murphy, she's not going to make the deadline, I'll let the court know.
All right, thank you.
Thank you, Your Honor.
Is there anything else?
No, not with respect to
Oh,
Mr.
did you say you
Dixon.
need to measure him or
I
something?
do, I'll do that in the back.
Okay,
And have Mr. Flores also here today, Judge.
all right. Deputy, are you okay with me doing his other client very quickly? All right. Flores.
Judge, on Mr. Flores, I've got some discovery issues
Mhm.
and I got appointed last night
To the other case.
to another case.
And I think that's the state jail felonies.
Yes, Your Honor, it is. It's an unauthorized use.
All right, what are the discovery issues?
Yes, Judge, on the manufacturing delivery case,
Mhm.
there are 11 large files. I had made a request on May the 10th for the large files via Veripic, but I never got it. I requested it last night, and I talked to Andrew about it this morning, and Andrew's got a advocate working on copying what they can for me right now.
Okay, I think you're probably gonna need a drive or something if it's too big.
I think so, Judge. I got 4 drives out in different cases right now, so I've got to get another drive.
All right,
And I told him I'd be back by Friday with the drive,
all right, so I'm gonna recall this for discovery for July 21st.
July 20th. Thank you, Judge.
You're welcome. All right, do you have any questions?
Is there a way I could get a bond?
You'll need to speak to your attorney and your attorney can file whatever motions in the court will hear it. All right,
Judge, I'll follow a motion.
all right, thank you.
Thank you, Your Honor.
Flores.
Okay, that's, I did that.
Oh, and counsel on
Yes, ma'am.
Flores, can you make sure that the attorney has the discovery on the state jail if there's something that you were given?
I talked to him about it. So they did turn over about 800 gigabytes. However, it was a mistake. The discovery I was given was on some murder case.
Ah,
I
okay.
think there was a JN switch up or something. So they're looking into it. They said, yeah, definitely a mistake. I don't think there's any additional. I think it just got mislabeled.
Okay,
But yeah, if I hear back from IT that there is more, I'll let them know.
all right. Wait, put this in here. All right, just give me a moment. Let's hear on Leon Small.
I am your.
Yes.
Mr. Small is in the custody of the Bureau of Prisons, or at least in federal marshal custody. He's got a federal case. I brought the court, the docketing sheet on his federal case off of Pacer. as well as his federal indictment, as well as, there's an order of detention, which is not contained in there, but there's reference to it. He was detained without bond over there. And I think his next, if you look at the very back page.
Yeah.
There's an order, setting a plea deadline. Yes, ma'am. So I think, I'm not representing him on the federal case, but I think, I hate to use the word artificial, but I don't know. I mean, these dates are certain dates for right now, but
They may change.
it will change. I believe.
Ms. Ferguson, I need a date in August for Mr. Small, late August, please.
And Judge, I hate to ask you this, but and anyone that could help me on it, is he showing up on bond or is there a way I could make an oral motion or does the court need me to file a written motion to go ahead and go off his bond, just so at least he's accumulating credit?
What I can tell you in this court, I mean, if you want to do that, of course, the court will do that. But in this court, your client has been in custody and he has a made bond. And if for some reason he were sentenced on this case, I would give him credit for the time that he's been in federal custody while this case was open.
Very well, Judge.
Because sometimes he may be found not guilty. Then he's like, I don't have a bond.
Right.
All right. What date, Ms. Ferguson? All right. Is there anything else, counsel?
No, ma'am, Your Honor.
All right. Good seeing you.
Pleasure seeing you.
All right.
Thank you, Judge.
You too. All right, so with federal cases, the federal court will not release a defendant to come to state court until their case has reached its conclusion. And there's nothing we can do about that. So we just have to wait until they finish. Sorry, that was mine. Trying to turn it down. Joe Grant. Yes.
Your Honor, Mr. Grant is on today's docket. I was
Yes.
just hired yesterday at 5 o'clock.
All right, Ms. Ferguson. I need a jury trial date for Mr. Grant, and if it works out, then there will not be a jury trial. So can you set this in July, please? Criminal Trial Division. It's a possession case. It shouldn't take that long. All right, July 22nd.
That's good, Your Honor.
All right, and that'll be your jury trial date and plea deadline date, and you can ask your client if he would like a bench trial.
I will do that, Your Honor.
All right, and normally you said the 22nd? All right, once you sign the reset form, you're excused.
Thank you very much.
Thank you.
Have a good day.
You too.
Thank you.
You're welcome. What I can tell both parties is one of the issues with this case is he has prior motions to revoke. Am I reading that correctly?
Yes, Judge, those prior motions to revoke were years ago, some years back, 2020, I believe.
Well,
And based on that motion to revoke, he was placed on deferred adjudication in that case for 3 years. And that 3-year term is coming on. He's already successfully completed that term.
okay.
During that motion to revoke, he was extended 5 years on this probation term.
Mhm.
So that's what happened with the motion to revokes. Or the latest one,
So basically he has about 2 more years on this.
2027, Judge. We have sent, this is the third request for early termination that we've sent in. One in February of 2024 and one in November of 2024.
All right. And State, have you reached out to the complainant?
We have, Your Honor.
And what is she requesting?
Your Honor, at this time, the complainant is requesting that the defendant remain on probation. We did speak to her about several instances that have occurred after these NTRs. One being very shortly after he was released from GPS on the NTR in 2021, he went over to the complainant's residence and was knocking on the door and stayed outside of her residence for
And
quite
what-
some time.
What year was this?
It was in October or November of 2021 after the last MTR. They did not report that to the police because she did not want any more drama with the defendant and didn't want to just cause anything else. So she did end up just leaving that residence. And then last year, the defendant reached out to her on TikTok and sent emojis and changed his profile picture to her profile picture. And the complainant did tell us that it just seems like nothing has changed, and that he's going to continue reaching out to her and bothering her. Additionally, Your Honor, the state just looks at the defendant's criminal
Well, let me ask
history.
this. So let's go back to the TikTok thing. I don't know about TikTok and how it works really. So, what's the proof that he did that?
Your Honor, I mean, I can have, I'm just proffering what the complainant has told me. If you would like to hear from the complainant, we can do
Well,
that.
I mean, I need some proof of things that are being said instead of just people saying it. I remember this case. I remember all the cases. And I remember this case in the very beginning, there was an issue with the complainant not being cooperative. And I understand when complainants are not cooperative, then they change their mind and different things happen. But if there are reports that just last year he was reaching out to her, then I need more than just somebody saying that. I need proof of that. So will you be able to provide proof, or if she wants to come in and give testimony, she can come in and give testimony?
Sure, Your Honor, she is available. She's ready right now to give testimony if the court would like to hear it.
All right. So do you have an attorney?
No.
All right. And you were given a court-appointed attorney previously?
Yes.
All right. So we will see that you have an attorney. Just one moment.
This case was set for last week,
And I'm like, ah.
and we were before Judge Angelini, and you know what happened.
Mhm. Yeah.
He picked another case.
Judge, did you have jurors on the 30th, the first and the second?
All right. So we would do jury selection on June 30th. And this will be the only case on the docket. So this will be going.
Okay.
All right. So we're rescheduling you for June 30th. Your attorney has a vacation. And I always tell people, don't get upset with your attorney for having a vacation, because everybody needs their mental health breaks and to just get away from all of this. There was a time when I would never do a vacation. And a defense attorney told me, he said, Stephanie, you should do a vacation with your family. What are you doing? I'm like, I got to keep working. And he said, Stephanie, if something were to happen to you and you were to die, he said, I would be very sad. But he said, you know what's going to happen? I'm like, what? And of course, you're all in your feelings. You're like, they're going to shut down the city. It's going to be a day of mourning. He said, what they're going to do is they're going to say, that's such a shame. And then who's taking our cases? And they're just going to give other people your cases. So attorneys need their mental health break, because attorneys deal with a lot, especially when you're a solo practitioner and you don't get a break. So I'm going to let him enjoy his fishing. Hopefully he will catch something. Yeah. You'll have to show us a photo of you holding the fish.
Oh, yeah.
All right. So we're going to come back on June 30th.
Yes.
All right. And is there anything else, counsel?
Nothing else, Judge.
All right. So we'll bring you back on June 30th. You'll be brought just for trial. We're going to call up the jury on Monday. State.
We're gonna do it early in the morning, I guess.
Yes. State, if you'll make sure that you have your witnesses and be ready for on Monday.
For testimony to begin on Monday?
Yes.
Yes, ma'am.
And so what will end up happening is, because they have to qualify jurors, we probably won't have a jury out in the hallway till 10 at the earliest. But then we're going to do jury selection. Then right after jury selection, we'll come back in the afternoon for testimony. All right.
And there's the two pretrial motions. It's just a limine and 404B. It's very simple.
All right. What's the motion in limine?
There's a limine and a 404B.
All right. If you'll confer with the state over that, what I can tell you is I don't know anything about your case. The only thing I know is what the charge is. So with regards to motion in limines, which means the defense, there's some things that he maybe doesn't want the state to mention before the state gets ready to question any witnesses about that or elicit any testimony. I'll have the jury step out, and then I'll be able to hear argument, and I'll know better what this case is about and what both parties say and the facts are, okay?
Yes, Your Honor.
And then the 404B,
Mhm.
if you'll talk to the state
I'll
and,
talk to them. I think I have their notice.
okay.
Okay.
All right, thank you.
Thanks, Judge. Maybe excuse their
Yes, you may be
texting me from the
Yeah.
front hall. Monday.
All right, let's talk about that. This hearing was a mix of sharp legal debate, procedural precision, and a few candid moments that showed Judge Boyd's signature style. The centerpiece was the bench trial of Carlos Vasquez Saldana, where the entire case hinged on whether his verbal consent to a vehicle search, given while handcuffed, was truly voluntary e-line, testimony, and body cam footage, pressing both sides for clarity. The defense leaned hard on perception, arguing that being cuffed late at night without clear communication would make anyone feel under arrest, so Miranda warnings should have been given before any consent. The state countered with case law, pointing out that Miranda isn't required for voluntary consent and highlighting details like officer safety concerns and a calm interaction on video. Boyd's questioning was thorough and even a touch Socratic, drilling into logic and tone, like whether a friendly officer demeanor might actually indicate voluntariness. In the end, she denied the suppression motion, setting the stage for a straightforward verdict of guilt and a carefully structured 2-year probated sentence with conditions like no home health employment, a TAP evaluation, and immigration advisories. What made this hearing compelling wasn't theatrics, but the quality of advocacy. Defense counsel delivered a vivid narrative, walking through every movement in the video and emphasizing the intimidation factor of handcuffs, tinted windows, and language barriers. The state's presentation was crisp, backing arguments with case citations and emphasizing links like matching construction gear and tools found in the car. Both sides were composed and respectful, which made Boyd's job easier. She could focus on substance rather than courtroom management. Witnesses added texture, especially the Spanish-speaking officer, whose testimony about delivering instructions and securing consent in Spanish was central to the ruling. Boyd's insistence on getting names, spellings, and license numbers on the record reflected her commitment to accuracy. The courtroom itself was calm but busy. Boyd toggled seamlessly between this trial, sentencing, and other cases, like Amanda Hernandez's deferred adjudication plea, where she delivered a thoughtful lecture about addiction, safety, and the seriousness of probation terms. Even in that context, she maintained her approachable tone, clarifying definitions like elderly, 55 plus, with a touch of humor, while still sending a serious message about compliance. Beyond the Saldana case, this docket revealed Boyd's leadership. She accommodated attorney scheduling conflicts with empathy, quipped about fishing trips and mental health breaks, and even slipped in practical life advice. Yet she never lost sight of accountability. Probation conditions were spelled out to the letter, complete with warnings about revocation and no contact orders. Her approach made the courtroom feel like a blend of law school seminar, accountability board, and a community hub where justice is transparent and human. Overall, this was a strong example of Boyd's no-nonsense, yet personable style. She's not one to rush a ruling. She asks tough questions, applies case law carefully, and explains her reasoning so both sides leave knowing exactly why she ruled as she did. It's a clinic in balancing fairness and firmness, proving that a well-run courtroom doesn't need theatrics to be captivating. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.